Hello, everyone, and thank you for joining us today for USDA's Consensus Program webinar, a study on states' policies and regulations per CO2-EOR storage, conventional ROZ and EOR in shale, looking at permitting, infrastructure, incentives, royalty owners, eminent domain, mineral pore space, and storage lease issues. I do apologize for the delay in us getting started. I will take responsibility for that for that delay. However, glad to be with you all. The Consensus Program, founded in 2008, seeks to educate the public, policymakers, industry, and other stakeholders and build a consensus on the wide array of benefits of carbon capture, utilization, and sequestration in clean coal technologies. We do this through a series of briefings, such as the one we're holding today, workshops, reports, such as what we'll be presenting today, as well as monthly news clips. This program is done in cooperation with the U.S. Department of Energy's Office of Fossil Energy. So we'd like to thank them for giving us the ability to complete this work and share it with you all. If you'd like to subscribe to our mailing list, please email my colleague Michelle Littlefield at mlittlefield@usda.org. We will hopefully have some time for questions at the end. I believe we'll be waiting until the end to answer those questions. And if you have any comments, please feel free to enter them into the Q&A box at the bottom. Today we'll have Mike Moore, Program Director at USDA, moderating this session. Tara Righetti of the University of Wyoming College of Law, where she is an Associate Professor of Law, and one of the authors of this study will be presenting. Following her will be, or in addition to her, will be Samuel Taylor, Assistant Director of Strategic Partnerships and Technology at the West Virginia Energy Institute, is also an author of this study. And our other two authors are Chris Koski, Director of the Professional Land Management Concentration at the University of Wyoming School of Energy Resources, and Jesse Richardson, Professor of Law and Lead Land Use Attorney at West Virginia University College of Law, and a doppelganger of Kevin Costner. So with that, I will pass it over to Mike to go ahead and kind of introduce us to the idea behind the study and why we carried it out. So with that, go ahead, Mike.
Alex, thank you very much. And this is great to have this group assembled today on this work that they've gotten done. The idea behind the study, and it comes from some of my own personal experiences and people I know in the C02-EOR world and other mineral resource areas, that when you go into a state and you start exploring around for things to do with mineral ownership and rights, in pipelines, running into issues with the produced water, other commodities that may be down there that are producible, some states that have been around for a lot longer than others. For example, Louisiana, when you get into state law, when it comes to mineral resources and land rights, it's all done under Napoleonic law, which if you're in the business, you know that. For most people, it kind of catches them off guard a little bit. And so we thought that there should be some time spent to look at what is going on at a state level when you start having to pay attention to pore space rights, mineral rights, subordinated commodities. And the other issue, especially when it comes to CO2-EOR and storage, is that we're handling both a commodity that's valuable in one area, but it's being regulated as a pollutant in another. And it can change a lot of relationships when you begin to use it subsurface, how you get it there, who's gonna own it, who's got liabilities with it. And I'm not in the legal profession, and I don't profess to be. So we figured we'd turn it over to the folks who would understand how to do this. And Professor Righetti and her team, University of Wyoming, and the folks at the West Virginia, University of West Virginia, I'll get all this straight, are the experts. And they took the time and they dug into this on a handful of pre-set up states to look, see what we would find. And I'll let them tell you what they discovered. I'm not surprised, but I think a lot of people will be, will find this very helpful and very insightful and probably an eye opener for some of our state regulators and politicians when it comes to looking what we do with these resources in the future and what kind of things might need to get sorted out, connected up, and maybe a little different approach to. With that, I'm going to turn it over to Tara, and it is all yours, and thank you.
All right, let me get the slides going up here. And okay, I hope you all can see the presentation now. Should be good. Okay, I see some nods. So it was a pleasure to work with West Virginia University and USEA on putting together this comparative study. Just quick disclaimer, basically says you shouldn't plan a project based on this resource alone. And then talking more about what we did. So we did a comparative study of 12 different states, focused in the sort of Appalachia region, as well as in the interior West and Rockies region, looking across a broad scope of different state laws and regulations. So our goal here, rather than doing a really deep dive into one state, was to see if we could identify some trends, consistencies and inconsistencies, different trends that were developing maybe regionally, as well as some state-to-state comparisons. And our goals were to see if we could identify areas of friction that may pose problems for an interstate project, either in terms of connecting sources to sinks, development of transportation infrastructure. And to do that, we tried to get a broad view of the regulatory and legal landscape in each of these states, as well as the interaction with federal law and federal lands in some of those states. So for our presentation today, Jesse and Chris are going to briefly highlight some of the comparative aspects of two states. And for purposes of just illustrating what we looked at and how those comparisons might sort of emerge, we've chosen to focus on Pennsylvania and Wyoming. And then after that, we're going to go through some of our significant findings. And at least for me, I think some of the findings were that across the board, there are areas of gaps and regulatory uncertainty. And in some places, that's a lot more than others. But even where it looks like policies may be homogeneous, within it, the deeper you dig into those, the more nuanced and the more differences you find. And so, you know, there really isn't a one-size-fits-all approach to either C02-EOR or geologic storage, or even things that you might think would be fairly straightforward or transparent and consistent, like understanding the scope of minerals included in a grant or reservation. So with that, I'll turn it over to Chris and Jesse for, or Chris to start with looking at the federal land component.
Thank you, Professor Rigetti. So as she mentioned, Jesse and I are going to just do a kind of a quick comparison of two states, Wyoming and Pennsylvania. And we think that those states are neat to look at from, you know, just the contrasting positions some of the states have taken with their law and that impact C02-EOR and storage projects. Now, while Wyoming has, you know, one of the you know, most probably favorable systems for C02-EOR and storage projects, one thing to real keep in mind and why we're talking about federal lands is in Wyoming, roughly half of the lands is federal lands. And in addition to that, another about 18.5% is what we call split estate lands, where private parties own the surface and the federal government owns the minerals. And because of that, it's really hard to have a project in a state like Wyoming and some of these other Western states without federal involvement. And so when you talk about federal lands, the federal lands piece is very important from a state perspective in a state such as Wyoming. And we've noticed some perhaps opportunities for the federal government to address what we think might be some gaps or challenges when it comes to CO2-EOR and storage projects. If you look at the slide, the first comment is the federal permitting process. If you're going to have an EOR project, you're going to need what we call an APD for any well, an application for permit to drill any well. What's interesting about that permitting process on a federal level, at least when it comes to Wyoming, it's relatively duplicative in the sense that a lot of the same things that are required to be approved at the federal level are also required to be approved in the state of Wyoming through the Wyoming Oil and Gas Conservation Commission. So the APD process from a federal level can be quite lengthy. And because you have federal involvement, I think a lot of the people on this call will know that any federal agency action is going to perhaps trigger, it will trigger what we call NEPA review. And so if there's the potential for environmental impacts, that will require sufficient NEPA analysis. So that is one area of perhaps an opportunity and a challenge. Another issue when it comes to CO2-EOR and specifically actually storage projects is, at least in a state like Wyoming, these western states, where you have split estates and federally owned minerals. It sounds a little bit strange, but we actually don't necessarily have the answer to who owns the pore space. And the pore space is, the microscopic gaps in the rock that allows you to store CO2. And where we have these split estates, we don't necessarily have a case that tells us, well, your split estate was formed under the Stock Raising Homestead Act. Who owns the pore space? On these federal split estates, we just really don't have that answer. Now, some commenters have opined that, well, where the federal government reserved minerals, they also reserved the pore space. The case is Williams v. Watt that they used to support their analysis. Other commentators have opined that, well, where you have this gap, you defer to state law. And in the state of, for Wyoming, for instance, Wyoming has a statute that says, unless there's something in the contrary to the deed, the pore space is owned by the surface owner. So that can obviously be a pretty big challenge, because if you don't know who owns the pore space, you really can't put together a storage project and aligning all those owners that you would need to line up for your project. So that's certainly an opportunity and something that probably needs to be addressed at a federal level to incentivize storage projects, especially where you have split estate minerals here in the West. As Jesse's going to talk about, that's not necessarily a bigger issue out east, where you don't have these federal mineral split estates. Another issue at the federal level is, well, what happens when you have multiple mineral or energy development, which can be a challenge to CO2-EOR and storage projects. Luckily, we now at least have a recent guidelines from the BLM that arose out of a dispute between a coal operator and an oil and gas operator, where the BLM said, well, if you can't accommodate both energy uses, BLM chose in that case to allow the coal operator to move forward. In the case is Peabody versus Bear Energy, and the BLM allowed the coal operator to move forward on the basis that the coal itself was more valuable. And that was contrasted to the fact that the oil and gas lease had actually come first, and that there had already been oil and gas development on the lease. Well, the BLM said the coal development in the short term will lead to increased revenues. Therefore, they allowed the coal operations to proceed. So at least we do have some sort of understanding how the BLM may address those disputes where we really didn't have a lot of understanding before that recent case. Another opportunity for the federal government to incentivize perhaps EOR, well, but more specifically storage projects of CO2 is we kind of have a gap when it comes to federal permitting and oversight of storage projects. For C02-EOR, you're probably regulated under the Mineral Leasing Act, and you deal with your oil and gas leases. Well, for a pure storage project, BLM generally looks to a separate federal law, which is the Federal Land Policy Management Act, or FLPMA. Well, the interesting thing is there was guidance several years ago on the use of FLPMA for issuing storage permits. However, that guidance has expired, and we don't necessarily have a clear regulatory system at a federal level. Once again, when you're in Wyoming, it'd be really hard to put together a project that's not going to involve federal lands or federal minerals. Now, there's certainly aspects to federal law that really can add to the ability to allow for CO2-EOR in storage projects, and that is the federal government itself has pretty broad eminent domain authority. So long as it's in the public interest, the federal government can exercise that authority. Obviously, you would need some sort of regulation and direction from Congress and the various federal agencies on that process, but there is the availability at a federal level for the use of federal eminent domain. And I'm not going to get into too much, but anytime you have federal lands, federal minerals, or federal agency actions involved, that's going to trigger the NEPA analysis. And that, as a lot of you know, can be relatively lengthy. And in addition to NEPA, there are several other federal environmental statutes that we go into in more depth in our paper, talking about CERCLA, RCRA, Clean Air Act, Clean Water Act, Saltwater Disposal Act, and various other federal environmental laws that can impact CO2-EOR and storage development. So with that said, I think we will move into the brief analysis on Wyoming state law and contrast that to the state of Pennsylvania when it comes to the existing laws and regulations for CO2-EOR and storage projects. One thing that I think you had heard me mention is that Wyoming has some of the most developed state law that is favorable to CO2-EOR and storage projects. The Wyoming legislature has gone to great lengths in developing this law. And when you compare the states that we looked at, Wyoming is one of the leaders when it comes to state law. But as I indicated, one of the issues in Wyoming is it's really hard to put together a project that's not going to involve some sort of federal law. So you need a little bit of harmonization there. However, when you ask what is favorable about Wyoming, well, first off, and this isn't true in all states, and you're going to hear from Jesse, is that Wyoming law allows for eminent domain use to basically secure easements for pipelines and roads to construct those pipelines. So if you're a private company and you want to do a CO2 storage project or EOR project, you're obviously going to need pipelines. Well, through Wyoming Constitution and statutory law, there is that availability of private companies to acquire those easements when you may have landowners that may push back a little bit through eminent domain. Now, I do note, we do know in Wyoming it at least extends to, the eminent domain law at least extends to roads and pipelines. There's currently a case in front of the Wyoming Supreme Court that I'm actually counsel on, and that is looking at whether the Wyoming Eminent Domain Act extends behind what we call these easements to facilities as well. So there is an issue as to whether Wyoming's Eminent Domain Act could be used for private companies for the construction of facilities. We should have clarification on that issue following this case. In addition, and Wyoming is one of two states with primacy over all the six classes of UIC injection wells. That means that Wyoming regulates the UIC injection wells at least to the EPA standards at a state level. As of October, Wyoming received primacy for Class 6 wells, which is injection for long-term storage of carbon. So Wyoming has a state permitting process that was recently set up to allow for that, North Dakota being the only other state with Class 6 primacy. And that's done through the Wyoming Department of Environmental Quality. For C02-EOR projects, Wyoming has Class 2 primacy over injection wells for EOR projects, and the permitting process is handled through the Wyoming Oil and Gas Conservation Commission. When you look at Wyoming's regulatory structure for specifically EOR projects, Wyoming has a very favorable structure in the fact that the Wyoming Oil and Gas Conservation Commission, if there's enough consent of owners, can order the unitization of basically large amounts of lands for EOR projects where you would allow for the sharing of production. Also, Wyoming has a recent statute that extends to the unitization of pore space to allow for a permitting process to basically allow for the consolidation of a whole bunch of lands for a storage project. And why that's important is there's very few lands where you could have one owner over a given reservoir that would be applicable to a C02-EOR or storage project. So the need for unitization is the fact that you're very likely to have multiple owners in any overlying or as far as the mineral state in any given reservoir. So Wyoming has addressed that through its regulatory authority. A couple of the challenges that we've noticed when it comes to Wyoming is that there is a question sometimes as to ownership of who owns the various minerals, who owns the pore space. And that's because Wyoming, through its case law, has kind of taken an ad hoc approach to the interpretation of mineral conveyances. Specifically, Wyoming, through its case law, has taken an intent of the parties-based approach where the court has said, you need to look at the instrument to determine what the parties intended. And if it's ambiguous, it allows for additional information to answer that question. So oftentimes in Wyoming, because we have this intent of the parties type analysis, it leads to instances where you don't have a lot of certainty as to ownership of the pore space or the minerals. And so that is a potential challenge for development in Wyoming because you're going to have to identify the ownership before you could start a project. Another potential challenge or opportunity is Wyoming has what's called a very defined Split Estates Act. And Wyoming Split Estates Act will give significant abilities of surface owners to negotiate and request surface impact payments for oil and gas operations. Generally, we say the mineral owner is dominant and the mineral owner can use so much of the surface as is reasonably necessary to develop the mineral estate. But Wyoming statute does kind of change that a little bit, and it requires any companies that plan any sort of oil and gas or C02-EOR operation to negotiate with the surface owner to reach an agreement on a surface impact payment. And if one can't be reached, then you go through a bonding process at the Oil and Gas Commission. So Wyoming does have a pretty lengthy split estates statute that provides a lot of say in any project from a surface owner standpoint. So in conclusion, because we have a lot to cover today, I'll just say that Wyoming's statutes and existing law are pretty expansive, are encouraging to C02-EOR and storage projects. But as I indicated, there are gaps there. And additionally, very few projects are not going to require federal input in Wyoming. So with that, I will hand it over to Jesse Richardson, who will contrast the law in Pennsylvania. So thank you.
Thank you, Chris. And as Chris said, Pennsylvania provides quite the contrast to Wyoming. And in general, we found that when we were doing our research on the eastern states, it was very, very different than what our colleagues at Wyoming were finding in the western states. Although, as we've talked about, there's the issue of federal lands and how that can complicate the issue. In the East, we have very little federal land, but we also generally, the states have little or sometimes no statutory framework for how to handle CO2. And Pennsylvania is very characteristic of that, representative of that. No statutory regime for CO2 sequestration. There's no CO2 distribution network. And for condemnation, to condemn land, to condemn areas for pipeline, to lay a pipeline or to operate a pipeline, you have to be a public utility corporation. So that presents a huge barrier to CO2 pipelines in the state. In addition, most of the eastern states had no statutory framework on pore space ownership, and the case law is often unclear. And in Pennsylvania, the case law is very unclear on who owns the pore space. This was an issue that the student who was doing the preliminary research on this and I actually got in a pretty heated argument about the various cases, and the cases actually seem to contradict each other. So a lot of uncertainty in Pennsylvania in that respect. And Pennsylvania consistently treats CO2 as a pollutant. There's no indication in Pennsylvania law that CO2 could be a commodity or could be monetized in any way. And we'll talk about in a minute how that's very much the case in Pennsylvania, or about to be possibly. And also, in contrast to Wyoming, and really this is fairly unique for Pennsylvania, Pennsylvania has not acquired primacy for any of the UIC categories. So the EPA administers the UIC programs for all classes of wells in Pennsylvania. So that framework shows you that there's not much in Pennsylvania. And then it's almost as if Pennsylvania is hostile to doing anything with CO2 sequestration or storage or the like. First, I'll talk really briefly about the Robinson Township case. And many of you perhaps have heard of this case because it was a very significant case, a very odd case. The state of Pennsylvania passed a statute, and it did a lot of things, but what I want to focus on here is that it required all local governments in Pennsylvania to allow oil and gas operations in every zoning classification. So whether it was single family residential, and that was the category that most people were worried about, or retail or whatever, they had to allow it. And Robinson Township is a fairly wealthy community outside of Pittsburgh. They obviously did not want to have hydraulic fracturing in their community. They and a doctor and some citizens filed a lawsuit challenging this. And much to the surprise of many of us, if not all of us, the Pennsylvania Supreme Court reached out and grabbed the Environmental Rights Amendment to their state constitution, which gives every citizen in the state the right to clean air, clean water, a clean environment, and says that the natural resources of the state are held in trust for the citizens of the state. And the court said that due to the Environmental Rights Amendment, that this state statute mandating oil and gas operations in all across local governments and providing a uniform state-imposed system of regulation. So the state would decide where they go, what the setbacks are, really every element of siting and regulating the oil and gas operations. The court said that violated the Environmental Rights Amendment. Now, since the Robinson Township case, the way I describe that case is that the court let the genie out of the bottle. And since that case, I think the court's been trying to get the genie back into the bottle, but with mixed success. So there's a real question of whether you could get a pipeline through Pennsylvania in this environment. And then finally, the governor of Pennsylvania is attempting to join the Regional Greenhouse Gas Initiative, which is a regional coalition of 10 New England and mid-Atlantic states that are seeking to basically eliminate carbon from our energy production sector. And the initiative has explicitly said that carbon storage and sequestration is not an allowable means to meet these reductions in carbon. So that also would seem to eliminate any economic incentive to engage in these activities. So you can see a huge difference between Pennsylvania and Wyoming. And now I'll turn it over to Tara, I believe, to start talking about some of our trends.
All right. Thanks, Jesse and Chris. So looking at trends, we broke these down into a number of different categories. Due to time constraints, we're not going to be able to cover all of them in this webinar, but if this fits well with your interest, I encourage you to look at the whole report. And so one of the first things we looked at is looking at the dominance of the mineral estate. And what we mean by this is particularly in the context of split estates where you have different surface and mineral ownership. There is an implied development easement to use the surface as is reasonably necessary for development of the underlying minerals. This could be important for C02-EOR because it includes use of the surface and the subsurface, like the pore space underneath, for things like injection. That also can be important for purposes of geologic storage, particularly if the pore space is considered part of the surface estate, because that would mean that the pore space would also be servient to other mineral uses in the same parcel or property. And unitization, as we've talked about, can modify the scope and extent of these common law easements. So what we were looking at in this case was the dominance of the mineral estate and how that had been changed either by statute or by case law. And so the very traditional common law rule that you can use the surface as much as you need to without paying any compensation has been modified by regulation or by developments in the common law in all of the states that we looked at. And so, but the ways that they've been modified vary significantly. So for example, we have the Wyoming Split Estate Act, which Chris talked about, which provides notice and negotiation and compensation requirements, allows surface owners to participate in certain proceedings. And then in Texas, we have the accommodation doctrine, which has evolved there and requires a mineral owner to reasonably accommodate the existing surface uses of the surface owner. Wyoming has statutorily adopted a duty of accommodation, which may or may not be interpreted as being consistent with the common law accommodation doctrine as it's developed in Texas. So looking at this, you can start to see that there's a lot of variations between states. And this isn't necessarily so much of an issue for regional CO2-EOR projects, right? The surface use is going to be happening at the location where you have surface disturbing activities. And so because it's very property specific, we're not necessarily looking at whether there's a conflict between the laws in Colorado and Wyoming, for example. But instead, these differences are going to really affect possibly the cost and the requirements associated with development, and may make some jurisdictions more favorable than others. Another issue that comes up with these statutes, Split Estate Act statutes, is that it's really unknown the extent to which a surface owner protection or a split estate statute might apply to subsurface uses by the mineral owner. That has been addressed by courts in both Montana and North Dakota, as well as legislatively in North Dakota. Another thing we looked at is pore space ownership. Who owns the pore space? And as Chris talked about, this may not apply to federal mineral reservations under the various 19th century land disposition acts. And the best thing that we can say with regards to that is that courts are going to look at the very specific language of the act making the disposition, or in the case of acquired lands, they're going to look at the statute or the contract under which those lands were acquired. And so what we're looking at is the language other minerals. And the question is, could pore space be an other mineral within the scope of those acquisitions or reservations? On a state-by-state level, though, the general consensus is that pore space is vested in the surface owner. In some places, this is addressed and acknowledged by courts through case law. For example, in Texas, there are a number of cases looking at that, but for example, the FPL farming case and the Manziel case and Lightning Oil v. Anadarko case, in all those cases, the court is consistently saying that the surface owner has interests in the subsurface, including in the hydrocarbon bearing strata. In Wyoming and North Dakota, for example, we have statutes that say, as of this date, we're declaring pore space to be owned as part of the surface estate. And then we have a whole bunch of states where there's no deciding case law or statute directly on point. Although in the US in general, it seems that the rule trends towards acknowledging that the surface owner owning the sky to the center of the earth, despite prior reservations or grants of minerals, has retained some interest in that subsurface. This is really important, and before I move on, I just want to mention this because where I see this as being most important is when you're looking at the issues associated with transitioning C02-EOR projects into geologic storage projects. So if you are conducting C02-EOR under the terms of an oil and gas lease, you have obtained those leasehold rights, which includes the right to use both the land surface and the subsurface as reasonably necessary to that oil and gas development. But at some point, if you want to convert a project and move it forward into a pure storage project, you have two issues. First, most mineral leases are granting a determinable interest that terminates at the time that production ceases in paying quantities. So if you're relying on mineral rights in order to inject that CO2, it's possible that at the end of your leasehold, because you're no longer producing, that possessory right goes away. You have no further right to continue using and occupying the surface. Another thing that has come up, which I find really interesting, is questions whether statutory obligations to reclaim the surface to its original case or as original state or common law obligations to that extent, could apply to an obligation to remove injected substances. And I know that those are that issue is being raised in a number of cases around the country. The other problem is once your lease terminates, you have no rights, but you also, that estate of the pore space estate and any voids that were, or vacuity that was created from removal of the oil reverts to the surface owner in these states. And so if you wanted to move from an EOR project into a geologic storage project, because of surface owner of pore space, you would have to, in most cases, go out and get an entirely new set of entitlements that would allow you to continue injection into the surface owner estate. And then the last issue I'm touching on before I hand this over is subsurface trespass. You know, in the context of C02-EOR, most states have said if you're within a unitized secondary recovery unit, there's something called the inverse rule of capture that protects the injector and the operator from liability for transboundary migration of injected substances within that unit. However, there's almost no law that looks at possibility of liability for transboundary migration in the context of geologic storage. North Dakota is the only one that has looked at this, and they have statutorily barred that. That law is currently being challenged in North Dakota courts. But for the most part, there's some standing. You know, really, we only have 2 states that haven't directly or clearly addressed this, but there's some standing to bring a claim for subsurface trespass. Could be either from the surface owner, the fee owner, or from the mineral owner. So, you know, for example, in Wyoming, there is a case, A&R Production v. Kerr-McGee, that looks at subsurface trespass and conversion of fracking between 2 different units. And so the question, you know, but that sort of establishes that a mineral owner could bring a claim for subsurface trespass. Of course, the most recognized cases in this area are Coastal Oil and Gas v. Garza in Texas, which doesn't directly address the issue, but holds that the rule of capture may prevent claims for damages in limited scenarios for drainage resulting from transboundary fracking. And then the Briggs case for Southwestern Energy, which was in Pennsylvania, and that case said that they did not find the rule of capture barred claims for subsurface trespass resulting again from transboundary fracking, provided that you could make that initial showing that you have an actual intrusion by proppant or fluid. All of this allows us to sort of speculate how courts would treat issues of migrating CO2 that's been injected for pure storage purposes. We also looked to some of the cases that relate to produced water injection because whereas EOR is protected by the fact that there is oil and gas production in geologic storage, without EOR, we're more looking at a waste disposal type law. And so the rules of subsurface trespass as they apply to fracking and EOR may not apply in the context of geologic storage. So Jesse, that's you again.
Yeah, I'm going to talk a little bit about local regulation of oil and gas development. And we do have time constraints. I could talk for hours about this, but I won't. Basically, we found that about half of the states had expressly or impliedly preempted local regulation of oil and gas development. And you can see North Dakota, Ohio, Pennsylvania, Texas, West Virginia, and Wyoming. The other half of the states had no express or implied preemption. I have an asterisk beside Montana because they really do preempt, except that there's a big loophole where landowners can form a zoning district and basically keep oil and gas operations out. Colorado is probably the most permissive, but I think if you boil down all of this preemption, no preemption, basically you look at all of the states. In every state, the local government retains some authority under the zoning ordinance to regulate the location and maybe setbacks and other aspects of oil and gas development. So often people talk of preemption as it's preempted or it's not. But with oil and gas development, there's really usually some type of regulation that the local government can do. In states like West Virginia, it can be difficult to find that local role in regulation, but there even in West Virginia, there are some things that local governments can do to regulate the location of oil and gas development. Kind of the rule of thumb is that local governments say where and the state government says how. But within that, one of the big sticking points is, can the local government ban oil and gas development totally? And the answer to that is generally no, they cannot, with very few exceptions. And this preemption might be under case law or statutory. Eminent domain is obviously a very important issue. The majority of the states that we looked at recognized eminent domain authority of pipeline operators. However, we found very few states that specifically mentioned CO2 pipelines. There are a lot of inconsistencies regarding common carrier requirements. When it comes to the subsurface, most states permit condemnation of subsurface rights for some purpose. Most broadly was West Virginia. But even there, each state's a little different, and whether you could do that for geologic storage is mostly uncertain. And there's kind of a cloud hanging over all of this, the Kelo case, where the United States Supreme Court found that local governments, state governments can condemn for economic development purposes. So a lot of states came in after that and said, well, not in our state, we're going to pass what I call anti-Kelo statute that says that you can't condemn for economic development. If CO2 operations are viewed as economic development, this could be a barrier. And then we have Wyoming, who prohibits the use of eminent domain for pore space. And finally, for me, I'm going to talk about water rights and produced water and acquiring water. For the most part, a lot of you have probably heard this. In the East, for surface water, it's riparian rights, which means if you own land that abuts a surface water body, you have the right to reasonable use of that water, sharing it with the other riparian owners. In the West, for surface water, the rule is predominantly prior appropriation, and that's what we found in our study. Groundwater is a little different. In the East, it's primarily reasonable use again. Tennessee is a little different. But in the West, Texas is very different. They use the rule of capture for water that raises a lot of interesting issues. For produced water, the Western states generally have some statutory schemes, and they might permit appropriation. In the East, we've historically had a lot of water, so we have not addressed that. The practice is that whoever injects the water, and when that water comes to the surface, the injector owns that water. But that's not memorialized in any statute or case law, so we really don't know. And all the states that we looked at allowed state and local governments to acquire water for various purposes.
I guess that leads back to me. I'll touch briefly on oil and gas regulation and unitization. I think I had mentioned earlier when talking about Wyoming, unitization, whether you're talking a C02-EOR or a storage project, is important because this concept is basically combining the parcels of various owners' land for a larger project. Well, when you're talking C02-EOR and storage, it's very unlikely that you just have one owner that owns the whole reservoir. So this issue of, do regulatory agencies have some sort of unitization power, that becomes really important for these projects. So all states that we looked at basically allow unitization, at least if there's some sort of voluntary consent of all the owners in the reservoir. But the issue arises when, what happens if you have a few holdouts? Can those holdouts basically preclude a project from happening? And so only a handful of the states that we looked at actually have some sort of forced pooling or forced unitization statutes where if you get a certain percentage of the owners, the regulatory agency might have authority to otherwise unitize the non-consenting owners in a EOR and perhaps the storage project. So as I indicated, almost all states have some sort of statutes that address unitization from a C02-EOR perspective, but we do have a gap largely in many of the states when we're talking about pore space. Relatively few states have actually taken this to the extent of allowing pore space unitization or have some sort of permitting or unitization process. In fact, of the states that we studied, only Kentucky, Montana, North Dakota, and Wyoming currently have statutes in place permitting pore space unitization. I'll briefly mention that Montana's statutes are currently pending. You know, and one of the issues that was addressed earlier is, you know, some states have yet to clarify exactly who the pore space owner is. So before you can get to this unitization of pore space question, you certainly have to be able to identify who the pore space owner is. As Professor Righetti mentioned, the trend appears to be that in all of the states, it appears that the surface owner is likely the owner of the pore space, but that is an unresolved question in certain states that have not addressed that question. You know, most states that were covered by this report, you know, do address CO2 underground storage to some extent, and as we mentioned earlier, Wyoming and North Dakota being the only two states that currently have UIC primacy over Class 6 carbon wells for long-term storage. So for the states that do not have primacy, that would be regulated by the EPA. So certainly for incentivizing long-term storage projects, the state acquiring primacy would certainly incentivize those types of projects. However, one of the significant gaps that exists in many states is, and that may preclude long-term storage projects from a feasibility standpoint, is the question of liability. Once that CO2 is injected, who's liable? Most states do find that the injector is liable, but some states have said after a certain period of monitoring and verification, the liability actually reverts to the state. In fact, Montana, North Dakota, and Kentucky have statutes that that address that. In the other states, it largely appears that the liability is going to stay with the injector. So this question of liability is certainly an opportunity for the various states and perhaps the federal government to address to incentivize long-term CO2 storage projects, and especially, even from C02-EOR that's being converted to long-term storage. And then the final big issue that exists when you talk about geologic storage is this issue of certification of stored CO2. Currently, most states lack any sort of certification process. In fact, Wyoming and Texas are the only two states that have some sort of certification mechanism in place, and both of those pertain to C02-EOR projects. Why this is potentially an important issue is considering the requirements of 45Q that can lead to tax credits and incentivize long-term storage projects. So that is an opportunity that exists, that is a potential gap that could incentivize long-term storage projects. So you've heard a lot of today about these general areas that can impact CO2-EOR and storage projects. I will now hand it over to Professor Righetti to kind of conclude our presentation today. Thank you.
Sorry, I was on mute. Okay, so as you guys sort of probably saw throughout this, there's a lot of uncertainty about the state regulatory frameworks. And even in looking at that last map where there's a lot of pink, the reasons those regulatory frameworks are partial or incomplete vary from state to state. So I think that there are legislative opportunities in all states to address some of these uncertainties. I think there's some things that are going to need to be developed by courts or addressed by the courts in those states as well. And then another thing we talked about is there's opportunities for regional coordination to harmonize requirements both between states and on a state and federal level. And then in some areas, although we didn't find this in general, it may be helpful to have federal backstop regulations to facilitate interstate components, particularly in places where getting an interstate CO2 pipeline may be difficult or impossible when you're trying to look at coordinating between multiple states with perhaps inapposite goals. I think, another thing, as Chris and I both mentioned, in the West, finding out a way to coordinate between states on federal lands is going to be critical. For example, Wyoming has pore space unitization. The Mineral Leasing Act Part 226M does not apply to pore space. And so, even though we have a template for how you approach unitization in EOR projects that have mixes of fee and federal lands, and when you would unitize under a federal process and when federal lands can be unitized through state processes, we don't have anything like that in the context of storage. And so it's unclear whether federal pore space could be included in a state unit or not. So, in brief summary, we had a lot of fun doing this project. We looked at 2 regions, and we think there's opportunities to continue studying and to link these together, particularly by bringing in the mid-continent and Southeast, as well as a little bit of the West and Southwest, to really get a picture of the regulatory frameworks nationwide, which I think would allow possibilities for modeling and identifying areas where there's the fewest barriers and uncertainty and that present good opportunities for storage projects. Again, I just want to thank USEA for their support and also acknowledge our tremendous student contributors who made incredible contributions to this project. And it wouldn't have been possible without them. So with that, Alex, if it's okay with you, we can do questions, or I'll let you take over here.
Yes, Thank you so much, Tara, and thank you to the rest of our presenters. This is a super interesting topic as well as an important one, especially in the context of 45Q regulations and more and more interest in CCUS. So thank you guys not only for this webinar, but for completing the study as well. That's much appreciated. I think we'll go until 12:30, if that's okay with you, with questions and comments. So I'll just go ahead and read the questions that have come in, and then if you can answer them, that'd be great. The first question that we answered in the chat, but in case not everyone saw it. In the Wyoming Peabody case, would the Bureau of Land Management have allowed both coal and storage to proceed if they are in different zones? Tara, I saw that you had answered it in the chat, but if you don't mind just reiterating that for the live audience, that'd be great.
Yeah, and I'll let Chris jump in here also if he wants. So that case involved a situation where you had well bores that were going through a shallow coal seam, and in Wyoming, it's open pit mining. And so the issue regarded whether there was a right of the coal company to mine through, and mining through, it's not possible to preserve those well bores. You have to like blast and remove the coal around them. So there would have to be a temporary plugging and abandonment of those wells, which, as Chris mentioned, predated the coal lease. And so in that particular case, the conflict wasn't over the subsurface strata where the coal was and where the storage project was, although I know people have looked at the possibility of storing CO2 in coal seams, so that could be an issue in other places. Here, it was on the fact that the wells had to physically be plugged in order for mining to proceed according to the mine plan. And we felt like if you were to drill through a shallow coal seam for a EOR well or a geologic storage well, that same situation could arise in a multiple mineral conflict scenario. And that therefore, the court and BLM's guidance on that matter might be important. So that's not a way to answer, how would it apply if they were in a different zones? And that's just because that wasn't addressed by the court in that case. So Chris, did you want to add anything?
Professor Rigetti did a great job explaining that case and how it applied. It really comes down to the issue of technical feasibility. Can you accommodate coal development with C02-EOR and storage development? If you're going to need an injection well anywhere near where the coal is going to be mined, my sense is no, that's probably not technically feasible. And BLM guidance would probably indicate that the coal project would be able to go forward first. But it's completely an issue of can the two energy developments coexist? If not, BLM has told us that it's going to go with the development that might be the most economically appetizing from the BLM's perspective.
Great, thank you both. We've had a couple requests for the link to the report. I will post that in a chat or in the chat box as we get through these questions. So another question or comment, there's a CCUS group in Pennsylvania, and any thoughts on how that can be impactful in addressing the issues identified here? Maybe a follow-up to that is, for certain state stakeholders, would there be an opportunity to kind of do a deep dive of this presentation, but focus on those states in particular?
Well, I'll address Pennsylvania first, and then Dr. Sam Taylor, who is also one of our co-authors, and Dr. Taylor was our technical person. When we had some really technical questions, we would bounce it off of him. But I've talked to the regional group, some of the people who form their policies. And my impression is that they consciously said, we're not going to give credit for carbon sequestration or storage, any of that type of thing. And you're right, there are some groups in Pennsylvania. I think Penn State does a lot. Presently, though, the governor of Pennsylvania wants to join. The Republican majority of the state legislature is trying to block that. If Pennsylvania ends up joining, I don't really see any space for promoting carbon sequestration and storage in Pennsylvania. But Sam, I don't know if you want to add anything to that.
I would agree with everything you said. The issues we're finding in Pennsylvania really get down to is their, legislative appetite for doing this type of work. The regulatory problems are solvable if there is, but if there isn't, if there's just generally we're not interested in these projects and we have no interest in, enabling opportunities for storage or enhanced oil or enhanced gas recovery, it becomes sort of a, no pun intended, but it becomes an academic question at that point. So, starting to understand the intent of some of these, the state governors and state legislatures, and whether there's, it's a problem that there's appetite for solution, or, in some of these cases, the barriers may be intentional, and that makes them a lot harder to cross.
Alex, can I address the question about why we chose these states?
Yeah, most definitely.
I meant to mention that in my introduction. So we started with these states because first they relied on our separate and sort of regional expertise. WVU took the lead on the Appalachia case, and we took the lead on the Western states, but we also picked them because we knew that there were some significant differences, for example, between prior appropriation and riparian doctrines, between the way that surface use issues were handled. And so we thought it would provide a nice basis for a comparative study. We know there's some major gaps here in terms of the fact of Mississippi, where a tremendous amount of carbon dioxide is produced, Louisiana, Oklahoma, as well as sort of filling in the gaps in the Midwest to connect those together. So we're hoping to move forward with a second phase of that and address those. And then also as we look sort of into connecting into California with Utah, Nevada, California, and some of the Southwest. We didn't see a need, at least at this point, to focus on Alaska because since it's geographically remote, we didn't see a lot of opportunities to look at the interconnectivity and comparative regulations. It's sort of a standalone state. And then also, we didn't see a tremendous need at this point to look either into the Northwest or into the Northeast. But yeah, very much hoping to continue that study and fill in the gaps to provide a bigger swath. And then the other reason is just time constraints. We wanted to get something done and out to everyone to start looking at. And so an initial 12-state study seemed like a great way to go about that.
That's right, Tara. Professor, I got a quick question, and it's kind of tied into this, and we talked through it while it was getting done. There's a number of states now that are pursuing lithium production from brine production. As EVs become more prevalent, demand for materials for batteries becomes more prevalent, lithium as a produced commodity with produced water is getting a lot more attention. Would lithium preempt or have a subordinated right to oil and gas or above oil and gas? And how would that fit for example, with produced water and pore space? And it's not, I don't expect you to have the answers to all of that, but it's more that it's something that's right now emerging on the horizon from about, I'd say about 4 different states right now.
Yeah, I think looking to that, there's a number of interesting issues, right? First, who owns those minerals? Were they included in initial mineral reservations or not? On federal lands, it's still going to be a locatable mineral, which is under the 1872 mining law. So, and that most people acknowledge is not particularly workable for rare earth element mining on public lands, at least at a scale. Then you have the issue with produced water. If the mineral owner, a different mineral owner than the oil and gas owner, has that right to the lithium, is there an obligation of the oil and gas owner to pull the lithium out of the brine to prevent waste, or if it's owned in that case by the surface owner? Most oil and gas leases don't include other minerals. And so, you may see an oil and gas and other hydrocarbon lease, or an oil and gas and helium lease, but less common to see something that would include all minerals. So I think looking at the parts of the report that would be relevant to that question would be the sections that look at resolution of multiple mineral conflicts, as well as the sections that looked on produced water regulations for appropriation and disposal. And finally, we've addressed in the report considerations about how courts in each state interpret the meaning of the term minerals in grants and conveyances and oil and gas leases.
I would say we're probably at the 12:30 point for us. Thank you very, very, very much for the great work that you've done. And as you've mentioned, looking forward to going to the next phases of the studies on these states. For anybody that's paying attention, I think Alex put the link up for the study itself. And I'm sure that everybody that was today speaking will be accessible by their emails, and happy to follow up with you further on some of the topics that were raised. There are a number of other questions that have come in since this session started on the Q&A. We'll try to get back to those with the participants here. Everybody, Professor Righetti, everybody there, thank you very, very, very much. And Alex, I'll flip to you to knock it out.
Mike, I couldn't have done it any better. So again, thank you all for presenting today. Thank you to everyone who attended. If you have any questions or concerns, I will share our contact information as well. I'll pull that up. And the slide decided not to show. Oh, there you go. Any questions or concerns from USCA for USCA? Here's our contact information. And with that, I hope everyone has a good rest of their week and a good weekend, and stay safe out there.
Thanks, everyone.
Thanks.
Tara, I can follow up with you on a call, or?
Yeah, that sounds great. If you want to give me a call, I'm available for the next half hour before class.
As soon as we're dropped here, I'll give you a call right back. And everybody, thank you for awesome work on that study and this presentation. I have a sneaking suspicion we're going to get a lot of follow-up inquiries on it. We probably touched a live nerve for a few folks, if they were paying attention, that have pre-existing operations or assets they're trying to do something different with. We probably woke them up. Anyway, well, I'll give you a call here shortly, and thank you, everybody. Thanks, Alex.
Thanks.
Thanks again.
Thank you all.